All right, Nabu, this is the last video I am recording for the summer term. There is another video that you have to watch, but I should explain. We take contracts in a different way than other courses that are delivered at Capilano University. Torts, however, is consistent across BADM 107, which is Introduction to Law, BADM 307, which is Advanced Law, and also the Nabu course. Okay, torts is consistent in Canada, the United States, Mexico, all sorts of legal systems. So consequently, the video that I did for my BADM 107 students on torts is the last chapter here. So when it starts off and it says, "Hi, BADM 107, do not panic." I think I even make reference to the chapters in the old textbook, but that doesn't matter because this chapter on contracts, our discussion of torts and sole proprietorships, partnerships, and corporations, I have put online the chapters from the BADM 107 textbook. Comment on that covers way more material than you have to know in contracts and forms of business organization. In torts, though, that chapter that I post is extremely good and applicable. Okay, that being said, we are getting into topic 8, which is slide 81, and it starts off with a definition of contracts as a promise or set of promises the law will enforce. This, in fact, is a very brief and sufficient definition because the actual definition would be far too long. In the late 1800s, Lord Herschel of the House of Lords in England had a case where he thought he was going to have to actually define contracts. Finally, he came back and he said, it's too complex, it's too large, it would be too long. Suffice it to say that a contract is a promise or set of promises the courts will enforce. That actually distinguishes contracts from what we call gratuitous promises, but we'll get into that shortly. So the other aspect of this, of course, is the fact that we're looking at international contracts, and there is a difference between how they are handled. So an international contract is an agreement drafted to accommodate business people in different jurisdictions, okay? One thing you have to know, and you absolutely have to know for real life and also for this course is the 6 binding elements of a contract. In the chapter in the textbook, if you elect to read it, and I certainly think you should, I start off by talking about how different authors treat the binding elements differently. The textbook we used to use in BADM 107, very expensive, huge, thick book, only used half of it, so finally we got rid of it. But it said there were 6 binding elements, okay? And then I looked at other textbooks, and some of them said, well, no, there's only 5, okay? And then they would say the first 2 are called consensus, not offer and acceptance. And then others said, well, there's only 4. And they'd leave off capacity to contract and legality of object. And then when you began reading, they'd talk about the 4 binding elements and then say, oh, and it also has to be legal, and the parties also have to have capacity. So I think what they were really trying to do was distinguish their textbooks from the other on the market. So anyway, you can read that and you'll understand better what I'm talking about. For our purposes, really, there are 6 binding elements of a contract: offer, acceptance, consideration, intention to create legal relations, capacity to contract, and legality of object. Okay. Now, I say to you, I'll sell you my car for $7,000, and you say, I accept. Do we have a contract? I mean, after all, I have not yet given you my car, and you have not yet paid for it. And a lot of people would say, no, we don't have a contract yet. That is wrong. And here's why. We would never in business say, I would like to have you give me your product on 30, 60, 90-day terms, okay, and then I will pay you later. If delivery, and performance was necessary for a contract to be binding. Okay, so you deliver me the product, I sell it, keep the money, and you go, hey, wait, I want to sue you, and you say, well, you can't because I haven't paid yet, so obviously there's no contract. Okay, so to facilitate business, we have what's called a bilateral contract. And if it isn't in the lecture guides, you should know. A bilateral contract is when I promise to give you my car and you promise to pay me. We have a contract. If you don't pay me and I've given you the car, I can sue you. If you pay me but I don't give you the car, you can sue me. All right? It's called, we're both a promise to abide by the contract from the outset. Okay, a bilateral contract, an exchange of promises. So obviously there's the offer, which is really important. The offeror makes an offer to the offeree on the conditions to be affected by the contract. So we have to look very briefly at the difference between an offer and an invitation to treat. Goods on the shelf in a store with a price tag, goods in a catalog, goods on the internet, are all invitations for you, the customer, to come in and make an offer to the business. This came about in a case in England where they clarified the law. England passed a law that said certain prescription drugs, certain drugs could not be sold except under the supervision of a pharmacist. And that's to protect people, okay? So you take one pill twice a day, one in the morning, one in the evening, the one in the morning before meals, the one in the evening after meals, and you turn around twice, stomp on your foot, and look and bay at the moon. All sorts of, I'm being facetious, but all sorts of, ridiculous things that are important for the drug to work properly and not hurt the people. So they passed this law, and after the law is in effect, a diligent civil servant skulks around the streets of London, finds a small pharmacy, goes in, goes to the shelf, finds one of these prohibited drugs, brings it up to the counter. He says, here's my 3 bob 6, or whatever their money is. It's all very confusing to me. But he gives the money, and then the clerk says, oh, I'm sorry, I have to get the pharmacist because we cannot sell this to you until after he's explained the ramifications. The civil servant goes, ha ha, gotcha. The contract is already complete. You sold the drugs. You're not a pharmacist. I'm going to go back and charge you with an offense. And that's what he did, right? Well, you get into court, and right away, the judges don't have a bias. Like, they're not conservatives, liberals, Republicans, Democrats, at least in England. And they're not, biased against business or hate unions or stuff like that. But they do have biases. And the biases is against stupidity, basically. And the law was working, wasn't it? I mean, it was to prevent people from getting a drug without instructions. So the clerk said, I'm going to get the pharmacist. So the law was working. Now the judge has to explain why the contract had not already been concluded, because if the contract has been concluded, then technically the pharmacy broke the law. And the judge said, goods on a shelf with a price tag are an invitation for the customer to come in and come to the counter with the product and give the money, and then the customer is making the offer. The clerk said, I'm sorry, I can't sell this to you until I get the pharmacist. There was no acceptance. If there's no acceptance, one of the binding elements is missing. Aha, being no contract. Okay? Well, that's England. Let's bring it a little closer to home. In Canada, there was a shop, well, there were a number of shops around Vancouver called Future Shop. And they posted online products for sale. They were one of the first to try to do this. They made a mistake. They put an MP3 player on sale for $9.99 instead of $99.99. Well, everybody tried to buy them, right? So the first, I think, 6 people went online and went, oh, wow, what a bargain. And they input their Visa or MasterCard and they hit the button. And then other people went in and they tried to do it, but by this time, Future Shop had noticed the error and closed down the site. Those people that had already used their MasterCard and got a transaction complete, got their MP3 players for $9.99 because they made an offer and the automatic site had accepted it. Offer, acceptance, consideration, okay. My consideration is I paid you. Your consideration is that you have to send me the MP3 player. And there was intention to create legal relations because that site was put up by a Future Shop. Everybody had capacity and it was legal. So those 6 got it. All the other people that tried and said, we should be able to do it because we tried. Well, no, because they tried to make an offer, but Future Shop said, no, we're not accepting that when they closed down the site. Okay, so there's the difference between an offer and an invitation to treat, or as we sometimes call it in Canada, and particularly in the United States, an invitation to do business. Now, I talked about how the definition of a contract is a promise or set of promises the law will enforce. Here's the difference between that and a gratuitous promise. There was a situation in the United States where a fellow was walking around the neighborhood of LA and he sees a garage sale, which is, funny, they're not selling the garage, there's stuff on the lawn that's for sale. And he sees a sketch and he looks at it and he goes, that looks like a Picasso. So he says to the fellow, how much for the sketch? And the fellow says, I don't know, make me an offer. And he says, I don't know, $20? The fellow thinks, $20 for an old sketch? This is great. Sure, sold. The fellow picks it up, gives him the $20, peels off the back, and he goes, yes, it is a Picasso. And the guy doing the garage says, oh, no, wait, you didn't pay me enough money. And, of course, obviously the court said it did not matter whether you made a good bargain or a bad bargain as long as there was a bargain. $20 to the garage sale person, that's his consideration. The purchaser got the Picasso sketch, and that was his consideration, so that it was binding. It happens in a number of situations. My close friend had 3 cars. He had the van for driving his daughters around because he had 3 of them. He had a little Ford Focus so he could pop out to the corner grocery store and buy milk. And then he had his toy, his MG, which is in mint condition. He'd rolled it out when the weather was like this outside, nice and sunny and warm and dry. And he would drive it to UBC where he was an instructor. And he'd never drive over 30 miles an hour because if you hit a bump with an MG, you lose your muffler. That's a joke. But they're very low to the ground. And then he would drive it back, and then as soon as the weather turned bad, he would put it away in the garage. Well, a friend of his at UBC needed cash immediately and desperately, and said he had a 1965 Ford Mustang convertible. And he said, I'll sell it to you for, $3,000 because I really need the money. And my friend said, well, why don't you sell it? And he said, I don't have time. And my friend said, no, I can't buy it. My wife would kill me if I brought another car home. And he said, well, you can take it home and resell it and you can get more. I just don't have time. So he buys it for $3,000, drives home. His wife meets him and says, no, you already have your toy. You don't get this one. He says, no, I'm just going to resell it. So he puts an ad in the paper, which is an invitation to treat, okay? And it says, 1965 Ford Mustang convertible, good condition, BO, which means best offer. My friend looks out his window, and there's a guy walking around the car kicking the tires. And my friend says, can I help you? And he says, yeah, I'd like to buy your car. How much? And Brian says, I don't know, make me an offer. And the guy says, $5,000? And my friend goes, yes, I made a cool $2,000 in just a couple of days. Sold. The fellow says, okay, I'll go away and get a certified check and you fill out the papers. My friend's filling out the papers and he looks at the window and there's another guy looking at the car. So he says, can I help you? The guy says, yeah. He says, I'd like to buy your car. And my friend says, oh, I'm sorry, it's already sold. Okay. And the fellow says, oh, darn, I really wanted it. If you don't mind me asking, how much you sell for? My friend said, $5,000. And the guy says, $5,000? He said, I would have paid you $15,000 for it. And my friend goes, oh, well, gosh, gee. And he races in the house and he gets on the phone to his lawyer, me, free legal advice. And he says, Peter, I haven't given him my car yet, and he hasn't paid me. We don't have a contract, do we? And we had both taken this BADM law course that talks about this in undergraduate. And as a matter of fact, we shared an apartment, we shared rides to the university, and we shared books. And the only when it was all over, the only book that we fought over to keep was the law text, and we flipped, and he won. So I said, you got the textbook, you read it. And he said, I have. He said, I'm bound to the contract because it's a bilateral contract. I promised to give him the car, he promised to pay me. And I said, right, correct. And he said, what if I just don't do it? And I said, well, then you'd better hope. If you're going to breach the first contract and accept the second offer, you'd better hope that the first person isn't a car dealer. And Brian says, I've got his business card, he's a car dealer. And I said, then he'll sue you because of the, he had a contract and he could sell it for much more later. All right. So he was upset that he only made $2,000, but the courts don't care whether you make a good contract or a bad contract as long as there's something of value going both ways. All right. One more story, and then we'll stop beating this topic to death. I say to you, I'll sell you my car for $7,000. And you go, oh man, I really want it, but I'm a poor, struggling student. I don't have any money. And I feel so sorry for you. But I say, okay, I'll give you my contract. All right. So I've made a promise to give it to you. I say, come by Friday and pick up the car. And you say, I accept. So you come by my house on Friday to get the car, and I go, sorry, I forgot I told you that. I've given it away to my niece because she needed a car. So can you sue me? Because here, well, if you were in a class with all the other students, you would have 35 witnesses that I made an offer and you accepted. No, you cannot sue me. Why? Because my offer is a gratuitous promise. Why is it gratuitous? It's gratuitous because you're getting consideration. Okay, consideration is has to go both ways. So you're getting consideration, but what consideration am I getting? I'm not getting any consideration. I'm getting that warm, fuzzy feeling in the pit of my stomach that I was going to help a student, but that isn't recognized at law. Okay, but I say, okay, I'll give you my card, and you go, oh, here's a toonie, buy yourself a coffee, and I dive across the desk and I punch 3 people and catch it because I'm a lawyer and I like money. Anyway, I get the toonie and they go, oh no, that's not enough. Well, the courts don't care if I sold my car for $2 because that's valuable, right? So that's some consideration. Okay, consideration is the price that you pay to get the promise from the other person. Okay, the price you pay in return for goods or services. Let's just pop down. Yeah, let's see. Do I want to say anything else about consideration other than it goes both ways? No, I think that's enough for our purposes. Okay, so let's talk about contracts themselves. And now we're going to form and substance. So a contract can be oral, like I'll sell you my car for $2,000, I accept. Or it can be partly written and partly oral. You write to me and you say, I'll buy your car, and I phone you up and say I accept. Well, part of it's in writing and part of it's oral. Or it can be a formal agreement where it's written down and it's intended to body the full contents of the agreement. We do contracts for certainty, okay, because you say, yes, I'll give you the distribution rights for BC, but I want to keep the area around Nanaimo for myself. We agree. What is the area around Nanaimo? You might think it's sort of metropolitan Nanaimo. I would think it was sort of, Parksville and, and some surrounding area. I might think it's the northern part of Vancouver Island. So you write it down and get legal advice from your lawyer because you want to make sure that it's as certain as possible. Well, when a lawyer gets instructions like that, they know the price of the distribution agreement, they know the contents of a distribution agreement and who's getting what and return policies and all that. They know the area to be covered, the parties' addresses and everything, because you give that to your lawyer. What the lawyer then does is put in a number of what lawyers call as boilerplate clauses. And we sort of shoot ourselves in the foot when we do that, because you have this contract and it looks pretty cool, and then you get to these other clauses and you say, oh man, look at all the clauses the lawyer added, and he must have just added those in order to bump up his bill. Okay. In fact, no, we call them boilerplate clauses because in a steamship, if you had the tank where the steam is made to drive the engines and turn the propellers, it would explode because the steam is so powerful, right? But you put boilerplate around it to hold it together, or to give it strength. And that's what we mean by boilerplate. And so let's look at some of those. One of the biggest difficulties entering into a contract is where the contract comes into existence. This was part and parcel of the problem in Sharn importing. Did the contract of guarantee come into existence in Alberta when it was signed, or was it signed in British Columbia? And you decide jurisdiction with those. Okay, so you're in Toronto and I'm in Vancouver, and I phone and make an offer to you, and you say I accept. Well, the contract was complete with acceptance in Vancouver, and so the court case will be fought in Vancouver. Okay. But if I write to you, there's a thing called the mail rule, which you can read about in the chapter. We don't have to know about it for the test. But if I write to you and you write back to me, does acceptance occur when I receive the envelope and I go, oh, look, acceptance? In fact, no, the mail rule says that because the post office is the agent for the person sending the mail, then, the agent for the person that's going to receive the mail, in other words, my agent. Well, if my agent can enter me into a contract, then when you put the letter in the mailbox in Toronto, it now belongs to my agent. That's my agent. The contract is complete. Okay, it might be 2 or 3 days before I even know that it's complete. That court case, because it came into existence in Toronto, would have to be fought in Toronto. Where the court case occurs, is an advantage. I mean, we saw that in the Heller versus Uber Technologies case, where Uber Technologies was trying to say, hey, the arbitration forum is in Netherlands. Well, yes, Uber can afford to send a lawyer to the Netherlands, but can an Uber driver? Okay, so obviously there are advantages to knowing where the contract comes into existence. But because it's different with respect to contracts entered into by mail, by courier, by fax, by telephone, by email. I thought there was another one, but anyway, because the rules are different, whoa. How do we avoid this problem? Well, the lawyer puts in a choice of forum and a choice of law clause. This contract shall be deemed to have come into existence in the city of North Vancouver, and the choice of law shall be the laws of the province of British Columbia. Bingo. Then you get into none of these arguments, and bingo, suddenly you have the advantage of having the court take place in North Vancouver. The choice of forum, choice of law. There was something I was going to say about that. We saw that also in the choice of law problem crop up in Sharn importing. Okay, so you put the lawyer puts those in for you. Well, that's when you're dealing, between Vancouver and Toronto, and Vancouver and Missouri, and Vancouver and France or Mexico or whatever. If you're in Vancouver, who cares? You don't have to put that in there. You're in North Vancouver, you sell product to somebody in Vancouver. They do not pay. You want to sue them. It's $28,000. The court limit for small claims court is 35, so you think, great, I can do this myself. You go to the registry in North Vancouver, and it is just off Lonsdale on St. George's and 23rd. There's a courthouse there. You go in, you file your notice of claim, and you serve it on the person in Vancouver, and they file a one-page defense. Wrong jurisdiction. What? Well, under the Small Claims Court Act, it says, okay, jurisdiction is based on a number of rules. And they're not surprising. One is where the contract comes into existence. Okay, that would be Lexus negotiae, and then or where the contract is to be performed, or where the contract is signed. Lex loci contractus, lex loci solutionis, lex loci negotiae. I think that's the third one. Anyway, okay, those rules kick in. Well, we don't want to deal with those rules, and let me explain why. Where's it to be performed? You pay me, so it's when I get the money, and he says, no, it's when you send me the product. So that doesn't help. Where's the contract come into existence? Well, we dealt on the telephone, so I can't remember whether I said I'll sell and you accepted, or whether you said I'll buy and I accepted. So that doesn't help. Where's it negotiated? Well, same problem, right? So rule number one is performance. Well, you don't know where it's performed, okay? And then the second rule says where the defendant resides. No problem. Oh, well, that's Vancouver. Oh, blast. I was supposed to start my court case in Vancouver. Okay. What's the big deal, right? Well, you have to drive over the Lionsgate Bridge, or Second Narrows Bridge, to go downtown and file your claim. You have to drive down to go to the settlement conference. You have to drive down for the trial. There's too many things on the docket. It doesn't go through that day. You have to drive down again. Then you finally win. Now you have to execute against the judgment debtor, and collect on your judgment. You have to go to court to do that. Well, that's 5 times you've gone across that bridge. I don't like that bridge, and I wouldn't have to enjoy going across 5 times. So even in a small contract, you want to put in this contract is deemed to come into existence in North Vancouver, and the law shall be the laws of the province of British Columbia, which is no problem if you're both in North Vancouver and Vancouver. But the second you get into Alberta or Quebec, you want to make sure you have a choice of law clause. Then you put in another clause called exclusion of conflicts of laws. Okay, so you just add it on. It comes into existence in North Vancouver, laws of the province of British Columbia, to the exclusion of conflicts of laws. Why? Because in an international case between British Columbia and a Missouri business, it said the laws of the province of British Columbia shall apply, and the person in Missouri sued, and so my client goes down, and I didn't do it, somebody else did, a lawyer there, and they get into court, and the lawyer said, oh, the laws of the province of British Columbia applies. And that judge said, Columbia, somewheres in the South America? He said, no way, nobody's going to tell me what law should apply in my court. I'm applying U.S. law. So it turned out to be a disaster, okay? So you want to put in exclusion of conflicts of law, because then there's no way that judge can say U.S. law can somehow work into this. Now, exclusion of the CISG we're going to deal with later. That's the Convention on the International Sale of Goods. A contract between a BC business and a business in the United States, if you just go ahead and sign it, and it's, and it turns out to be breached and there's a lawsuit, the really weird thing is the Convention on the International Sale of Goods applies. Why? Because this convention was passed by the United Nations All the countries, just about all the countries in the world, are signatories. And BC has passed enabling legislation, has almost every other jurisdiction in the world, which means that the convention applies. Like who cares? Well, you'll care because the rules in the convention are predominantly those of civil law jurisdictions, not common law jurisdictions. And so you might wind up in a trap accidentally by some rule of civil law that you're not familiar with in common law. For example, when contracts are entered into by mail, common law has this mail rule. If an offer is made by mail, acceptance occurs when a properly addressed stamped envelope is put in the mailbox. Civil law says when an offer is made by mail, acceptance occurs when the acceptance letter arrives to the offeror. Completely different, okay? Common law has a parole evidence rule. Civil law doesn't. And so when they negotiated this convention, there were more civil law jurisdictions in the world than there were common law. And so to get the thing passed, most of the rules follow civil law. So you do not want that. And so you say, oh, but I've excluded conflicts of laws. Well, that's not a conflict of law. Think this through because it would make a good exam question. BC has its laws. Missouri has its laws. They can conflict. But if both BC and Missouri have to follow the Convention on the International Sale of Goods, there can be no conflict. Okay? So if you do not want the convention to apply, then you have to actually exclude it. It's either Article 5 or 8 of the Convention on the International Sale of Goods Act says you can exclude the application, but you have to be specific. Okay, so between BC and Mexico business, this may become a point of negotiation. Okay, you want BC law to apply, they want Mexican law or the CISG to apply, and so it may be that you have to come to some accommodation. Now, the fifth clause that goes in quite often is called a fair negotiation clause, and I became aware of this when I had a client that was in the software industry, and they had their business in Burnaby. And they produced software, and a huge software company in the United States came to them and they said, we want you to pound out certain software for us. And here's our contract. And so the client sent the contract down to me to review, and I looked at it, and it was so one-sided. It was like everything in favor of the U.S. Business. And I called up my client and I said, are you going to sign this? I mean, it's like you have no rights whatsoever. And they said, we don't care because this is such an opportunity to make a huge amount of money and have access to markets that we could never do ourselves. That we want to do it. And they had that contract for 17 years that I know of without any problems. Okay. But when I went through that contract, I got down to one clause that says the parties here to acknowledge and agree that this contract has been fairly negotiated. On what planet in what universe was that fairly negotiated? It was basically a standard form contract, a contract where one party says take it or leave it. All right. And I called up the lawyer in New York, and I said, I got to ask you about this clause because it says it's fairly negotiated. Like, why is that even in there? I've never seen it before. And he said, oh, ignore that. Okay. He said, that's in there for our Mexican businesses that we deal with. And I said, why? What do you mean? The federal government in Mexico had passed a law because they get beaten up in negotiations. Mexican businesses get beaten up in negotiations by American businesses all the time. And they said, so we passed this law that says the contract has been fairly negotiated to protect the Mexican businesses. Okay. I'm not quite sure how that protects them. The assumption was that both parties would fairly negotiate it because there's going to be this clause in there. Basically, the Mexican companies would sign it saying, yes, it's been fairly negotiated because they don't have a choice. And then the last one, it goes back to the chapter on Canadian legal system, which ended with the topic on arbitration. Every contract should have a mediation and arbitration clause in there. Stay out of the courts whenever you possibly can. So those are really important clauses that have to go into every contract. Or I shouldn't say have to, okay, they should, okay. And then there's one other one that we have to talk about specifically because of the COVID-19 pandemic. And that is the force majeure clause. In common law, we have this doctrine of frustration. And the most frustrating thing about the doctrine of frustration is that you have no idea how it actually is going to work when the dust settles. What it says is if I cannot perform my contract through some reason beyond my control, then the courts will step in and see how it should be settled so that the contract is no longer in place. The difficulty with that is if you have, generally they just say the contract is void. Pardon me, they just say the contract is void. It ends like right there. But if I delivered goods and you haven't paid for it in the end of the contract, that means you get the goods for free. Okay? But if I have started making them in my plant, but I haven't delivered them yet, and the contract is void, I've got all the stuff in my plant that I've been making that I don't get. Okay, and if the other party has a deadline and they need the product to meet another contract, and this contract is determined to be void, then there's no impetus on me to supply you, and you're in breach of another contract. So the doctrine of frustration is very complex, and it's a nightmare. The civil law jurisdictions developed this concept of a force majeure clause. And they put it into contracts where if the contract for some reason becomes unable to be performed by one of the parties, the contract, instead of being voided, which causes all sorts of problems, is merely suspended. So the contract is suspended until you can get your workers back to work safely with testing, and you know that they're not going to be COVID-19 positive. And that prevents difficulties. Okay, so force majeure, I cannot make the product. The other company says I'm supposed to deliver product, but I cannot because of the force majeure there, so I have force majeure. And so everything sort of is put on hold. Now eventually it may turn out that the company cannot get back to work, that it goes insolvent, because they had to delay production too long, then the doctrine of frustration will step in, all right? But the force majeure clause is very advantageous because it does allow you this opportunity to have the contract put on hold rather than have the doctrine of frustration apply. So on slide 85, I've given you a sample clause. One of the problems that they're experiencing in numerous places now is whether the wording of the clause covers COVID-19. This particular clause, let's see, I'm just going to have to move my screen over so I can read it. In the event of an inability or failure by the company to manufacture, supply, or ship any of the products, for a reason of fire, explosion, war, riot, strike, walkout, labor controversy, flood, shortage of water, power, labor, transportation facilities, or necessary materials or supplies, default or failure of the carriers, breakdown of the loss or production, or anticipated production from the plant or equipment, act of God or public enemy, any law problems, government authority intervening, or any other direct cause beyond the reasonable control of the company. Well, COVID-19 is not a direct cause. So you're in court arguing that a breakdown in the loss of production or anticipated production from the plant or equipment. You could say that the fact that most of your workforce died of COVID-19 is a breakdown. Act of God, is a virus an act of God? No, acts of God are generally hurricanes and typhoons and things like that. So what else have we got there? Well, we've got a problem, okay? So does it apply or doesn't it apply? You are going to be in court, and there will be some court decisions to determine whether or not COVID-19 is covered. Now, that's just one clause. That isn't the standard clause used by every business in the whole world. So you draft your own clause, and in the future, you might want to put in a clause or another phrase saying breakdown and cessation due to pandemics. Okay, so there's another thought. All right. Now, a few other boilerplate clauses that really have to be discussed are the entire agreement clause and the execution in counterparts. You're negotiating a contract. Peak Performance Pontoons is going to deliver 500 pairs of skis so that you can sell them, but you're going to have to demo the skis in order to have purchasers buy them. Well, okay, you want the 500 to sell, but you say, okay, well, send me a pair of your beginner skis, a pair of your intermediate skis, and a pair of your high performance skis so that I can use those as demos, okay, because then they're used and you cannot sell them. So you say, okay, you buy all the other skis for $138,000 and I'll give you 3 pairs. Then you draft this agreement that is supposed to contain the whole agreement between the parties. And my lawyer drafts it and gives it to you, and you look at it and you go, okay, yeah, it covers the skis I'm buying, but where are the demos? And you say, well, why would I put the demos in there? You're not buying the demos. This is a purchase and sale agreement. I'm giving you those skis, okay? And you go, okay, oh yeah, right, of course. So I ship the skis, you pay for them, and you say, I didn't receive the demos. And I go, oh, okay, look, things are a little tight because of the COVID-19 thing. And so I've decided that if you want demo skis, you should use some of the ones I sent to you, or you have to buy 3 more pairs. And you go, no, part of the deal was. And I go, hey, parole evidence rule. The parole evidence rule in the common law jurisdiction says that anything that should be in the written form of the contract that isn't is considered extraneous and not binding. Okay, the courts look at only the contract. So you say, well, I wouldn't have bought them if you didn't give me that. And the courts will look at you and say, well, then why didn't you put that phrase in there? Or a clause saying you get 3. And you go, well, because I wasn't buying those. And you go, no, you weren't buying them, but it was part of the deal, wasn't it? Why didn't you put it in? Okay, because of the parole evidence rule, which is common law and is excluded by the Convention on the International Sale of Goods and not recognized in most civil law jurisdictions, because common law has this rule. Lawyers in the common law jurisdictions and lawyers in civil law jurisdictions put in a clause called the entire agreement clause, and I'm just going to quickly read that. This agreement represents the entire agreement between the parties with regard to the sale of the equipment herein and supersedes all prior oral and written proposals and communications. We put that in, which effectively makes the parole evidence rule obsolete in both jurisdictions, right? Because you now don't have a common law rule, you have a contractual clause. What you should look at that and do is when your lawyer gives it to you, say oral representations. Does that refer to the 3 pairs of demo skis? Or the lawyer conversely will say, are there are there any oral representations, not embodied in the contract? And you'll say, well, just the 3 demo skis. And your lawyer will say, oh, well, wait. You got to either put that in there or it's a gratuitous promise. Okay, he promised to give you the skis. Well, your consideration is that you're going to get the skis. What consideration is the vendor getting? He's not getting any. Okay, so there isn't consideration going both ways, and that's not binding. So we put that clause in there because it is, in effect, the parole evidence rule, but it prevents these problems if the parties really turn their mind to it. Very common clause in international contracts is execution and counterparts. I'm here, you're in Mexico. We negotiate the agreement, online, by emails, whatever. So now I have my lawyer draft the contract. I don't want to fly all the way down there to be with you so we can both sign it, and you sure as heck don't want to fly all the way up to Vancouver to be together to both sign it. So what I do is I have 2 copies of the agreement, okay? 4 copies of the agreement. I sign both in Vancouver. I send 2, or you run off 2 copies in Mexico. You sign both. Now, my signatures are on these 2, and your signatures are on these 2. We don't have a written contract in force yet, but I send you one of mine that's signed, and you send me one of yours that is signed. I take the one I've got that I signed and the one that you sent me that you signed, and I staple them together. If there's an execution and counterparts clause in the contract, I now have a binding agreement with you. You do exactly the same. You staple the 2 together, and then we have a contract without the necessity of travel. We have talked briefly about execution of documents under seal, I believe. If not, then now's the time to do it. And I usually have a lot of fun in class with this because I bring in copies of actual plaques and tankards with my family crest on it. Documents are signed under seal from ye old English days, and in other jurisdictions it evolved the same way, basically, but way back when contracts were being sold, neither party often could read or write. Well, how can you enter into the contract for the purchase and sale of land with a 10-page document if neither of you can read or write? Well, the document would be drafted, and somebody I trust would read it to me, and somebody that you trust would read it to you, and then I would put my X on it, and you would put your X on it. The problem is the X's look pretty much the same, all right? And so 2 years later, when we're in court and we're fighting about this, how do we know that's your X and not my X? And how do we know that those X's actually belong to us? And so there are all sorts of difficulties about that. When I was at law school, I had the contract professor who dug out an old case from like 1480 or something, where exactly that happened. A farmer was going to sign this contract, and he knew that there had been problems in the past with the X's. So he puts the X on the contract, and he turns to his elder son, and he says, remember that this day on this contract, the top X is mine. The son goes, yeah, like sure. Kids do, right? He says, no, I really want you to remember. This is really important. The son goes, yeah, sure. So the father's not satisfied. He picks up a piece of wood and he goes, whack, and he hits the son in the side of the head. The son says, whoa, what did you do that for? He said, I want you to remember on this document, the top X is mine. You just saw me put it on there. Kid says, okay. A couple of years later, there is this court battle. To get into court, the farmer says, yes, the top X is mine. Judge goes, looks pretty much like the bottom X, like, how do you know that's even your X? He says, oh, I remember, and I have a witness. The judge goes, oh, really? Okay, we'll bring the witness. So they put the son on the stand, and the judge says, son, how can you be sure that that's your X, or your father's X? Kid goes, see this scar here? My father picked up a piece of wood and hit me on the side of the head to make sure that I would remember. The judge says, okay, that's good evidence, and he accepts that the contract is complete. Well, pardon me, but we can't go around hitting people on the side of the head with a stick every time we want to make sure that they remember that the contract was signed, because at some point they're not going to remember anything. Anyway, the custom after that grew up that you would put an X there, and then you would use your family crest. Mine is on a tankard, a pewter mug, and it shows a shield, which is the shape of our family shield, and on there's a mailed fist. That's an armored fist. I like that for a lawyer. That's a really good symbol. Anyway, that would be our family crest. My ancient parents, grandparents, grandparents would put their X there. They'd melt some wax on the paper, and then they would impress their family crest into the wax. And that meant that this is their act and deed, and eventually it became so incredibly significant that a document signed under seal is binding even in the absence of consideration. So if I made you a gratuitous promise that I would give you my car, and you said, well, here's just a little note saying that you'll do that, and here's where you signed. Could you put your family crest there? And I go, oh, sure. And so I sign, and I put some wax on there, and I put my family crest there. And then I say, oh, no, I gave the car away. I cannot give it to you. That was just a gratuitous promise. You'd take me to court, and the judge would say, well, you signed under seal. Therefore, no consideration is necessary. He gets to sue you because you've breached the contract to give him the car. Okay, so that's how seals developed. Now I'm just going to go on hold here for one moment because we don't run around now with a signet ring with our family's crest on it, nor do we have a little stick with a family crest on it. But we do use seals all the time, and I've got some that I'll show you. Continuing on with the concept of seals. And how it affects consideration in contracts. I said that nowadays we don't have the signet rings and wax impressions on documents, so we use little red wafers that you can buy in a package like this. You just peel one off and you stick it on, and that's considered to be a seal. Question, why red? Again, back in historical times, when they had to start sealing these documents, they needed wax. Where's wax available in quantities sufficient? In a church, they have white candles and red candles. White for the purity of Christ and red for the blood of Christ, I believe. Anyway, they tried using white, but because it was translucent, the seal impression did not show up. Red had dye in it, so the crest would show up, and so consequently they used red wax. It became the tradition, and so when they started making wafers, they just made them red. My Act and My Deed, the case is the Royal Bank versus Kiska case, and I would like to deal with that in considerable depth, somewhat like Sharn, because of a number of things, and you'll see those as we go through. This was a situation where a young lad was asked by the bank to sign a guarantee in support of his brother's business. His brother had a hair salon and was indebted to the bank, and the bank was threatening to sue the brother unless he could provide additional security, and he didn't have any, so they accepted the guarantee of his brother, younger brother, who ran a pizzeria. And the young brother went in and signed a guarantee, and you can read, what representations were made to him and that sort of thing. I just want to cut to the chase. It went to the Court of Appeal. 2 judges said he was bound by this document. 1 judge dissented. And the interesting thing here is the judge's dissent was far better and far more clear than the other 2 judges. Anyway, the other 2 judges said no, he had to pay, so he had to pay. The judge that dissented, Laskin, went on to become a Supreme Court of Canada judge, and one of the best judges we have ever had. So, looking at page 41 of the lecture materials, it says, at the time he wrote his name on the first guarantee, this is the younger brother, no wafer seal was affixed to it, The word seal in brackets was printed upon the document immediately to the right of the space in which his signature was written, and an attesting witness had signed his name. So the fact that your signature is witnessed by someone doesn't make it under seal. Now, when it says the word seal in a bracket, nobody wrote that on. That was printed on the form, the standard guarantee form that they use. Now, he signed that guarantee, and then the bank sued him on the guarantee, and he was aghast to find out that he was actually going to have to pay money. So he's at the bank, and they show him the guarantee, and he's somewhat surprised to see that there's a seal on it because it wasn't there at the time he signed it. They say he has to pay, and the funny thing is the defendant became upset, that's the younger brother, and in the belief that without his signature on the first guarantee it would not be enforceable, he tore it from the guarantee and swallowed that portion bearing his signature. So in the bank, there he is, and he goes, rips it off, starts eating it. They grabbed him and tried to stop him, but he managed to swallow it. I mean, sometimes the law is just so much fun. The police were immediately called, and while they were present, a new form of guarantee was signed by the plaintiff, and it can be distinguished because this one had the seal on it. Then eventually it winds up in court, and the lawyer for the young man defends on two principles. One is the first guarantee was not signed under seal, and that the plaintiff gave no consideration for it. Okay, there's the whole idea of consideration. The execution of the second guarantee was procured by duress. All right. So then you can read the decision of the two judges if you want. It goes on for pages and pages, and it's basically wrong. Then we get to Laskin's dissenting opinion, and he starts off on page 50 of our materials saying, the law is clear, even trite, what's that mean? It's so ridiculously obvious we shouldn't have to talk about it. Most judges, when they say it's trite law, go on to talk about it anyway, as he does. That a portion of a that a promise of forbearance for no defined period is sufficient consideration for the guarantee of a third person to the indebtedness of another to be binding. Okay, as long as it's in writing and it's enforceable, a guarantor, because there's consideration there, even without the seal. Why? The bank's consideration is they're getting the guarantee. The person that signed the guarantee, I'm sorry, my allergies are not acting up. The person that signed it gets guarantee because the bank says they will not sue the other party. So he says, yeah, that's true. Okay, and that was the other two judges' position, that the bank said, well, we didn't sue your brother, and so that's good consideration to bind you to the guarantee, even in the absence of consideration. But then Laskin goes on to say, the recital of consideration is between the parties on the form, merely relieves the bank of the burden of establishing consideration. Okay, so the form says, let's see, what did it say? Guarantee and postponement of claim is what it was called. And then it says, for valuable consideration, receipt whereof is hereby acknowledged. Okay. So what they're saying is, well, it's you've agreed that we gave you consideration. Laskin says that just having that on the form means the bank does not have to prove that they actually gave consideration, but the defendant can still establish that no consideration was given. So this is the reverse onus provision. Remember we saw that in Sharn Importing? Babcock says, oh, I signed it in Edmonton. Well, the only person that could know was Babcock. And so the judge said, you have to prove that you signed it in Vancouver. Same thing here. The bank does not have to prove that they gave consideration, but it is up to Kiska to prove that no consideration was given. The fact that a document signed under seal is your act and deed is evident because on page 51 in the second paragraph, about the middle, it says, what it had in mind was to bind the defendant by a deed. So you can see that if you're signing a document under seal, it is your deed. Where the bank had trouble was that document did not say, you sign the guarantee and we will forbear suing. Okay, it just said sign the guarantee. And then the bank puts in that clause that I just finished talking about, the entire agreement clause. And this is on page 51 in the next paragraph, or indented paragraph. This instrument covers all agreements between the parties hereto relative to this guarantee and assignment and postponement, and none of the parties shall be bound by any representation or promise made by any person relative thereto which is not embodied therein. And so what that means is the fact that they verbally said that they would forbear suing isn't part of the agreement. Okay. Now afterwards they did say we postponed, but that was afterwards. There was no indication of that beforehand. Okay, and so they're not bound by Kiska's not bound by this promise of postponement anyway, because they say it isn't. So the bank really shot itself in the foot there, and surprisingly, the other two judges came to the rescue of the bank. Okay, this concept of the wafer, on top of page 53, it says, whether wax nor an impression is no longer obligatory. Neither wax nor an impression is any longer obligatory. A gummed wafer is enough when affixed by or acknowledged by the party executing the document on which it was placed. Okay, so those wafers are binding. There's law that proves it. The next paragraph down, they talk about the formalities of this. Okay, we talked about verbal contracts, which are informal, and then we talked about the very formal contracts. Well, this is a formal contract. You have formalities, you have to attend to them. Neither the words given under seal nor the formula of signed, sealed, and delivered suffices, even when taken collectively, make a signatory chargeable under a seal instrument when it is not in fact executed under seal. The representative words are merely anticipatory of a formality which must be observed and are not a substitute for it. So all those printed things on the forms aren't binding. Okay, bottom of page 54, there's a paragraph that discusses intention. Remember, there has to be offer, acceptance, consideration, intention, and legality and capacity. So Laskin deals with the whole concept of intention. More importantly, though, than that paragraph, on page 56, it says the bracketed word seal, I think, because this is merely an invitation to place a seal at that spot, means that you're not dispensing with the formalities. It affirms the need that the seal actually be put on there. Then in the last paragraph, it says there must be something in the nature of a seal, some mark to indicate a seal affixed to the signature to constitute a document signed under seal. The intention to seal under these circumstances, whether expressed or implied, does not make a seal. So in fact, you can actually intend to sign a document under seal. The seal isn't put on, and even though you intended to be bound, you won't be, because there's no consideration going both ways. All right, so Laskin is the dissenting judge. He loses. Kiska has to pay. So, why dwell on it? Well, you dwell on it because in subsequent cases, other judges in other jurisdictions in Canada pointed out quite clearly that Laskin was correct and the other two were wrong. So in the BC Supreme Court case of Noren, which is on page 57, when did Kiska take place? What was the date? Let's just go back. Hopefully I've put it on there. Sorry about that. 67. Okay, in 1967, Laskin makes his opinion. In 1983, 86 rather, in BC, the BC Court of Appeal says the requirements of consideration sufficient to support a guarantee was stated by Laskin J.A., Justice of the Appeal Court, as he then was because he became a Supreme Court judge, in the Ontario Court of Appeal decision of Royal Bank versus Kiska. Well, obviously, they look at the judges that made the majority, and they go, not paying attention to that, and then they look at Laskin and they say, that's correct. Okay. Why doesn't the BC court overrule it? Well, number one, it's a lower court. Number two, you cannot overrule the law in another jurisdiction. Okay. You can only overrule your own law. Okay. You can't change the law of Ontario and BC. Then there's an interesting case at the same time in 1967 where someone signed a document and put his thumbprint on there. And he got sued, and the other side said, hey, he signed under seal. And the judge in that case, the BC Supreme Court said, there was nothing more than a finger impression. There must be at least be evidence of the intent to adopt the document under seal. And they said your thumbprint is just identification. And then the real kicker is the BC Court of Appeal in 1997 really pointed out that the two judges in Kiska were wrong and that the right judge was Laskin. So I'm on page 58. In Kiska, a strong dissent was entered by Laskin J.A. Strong, as he then was. Okay. Who would have found that in the absence of any promise of forbearance was fatal, and the fact that the bank may have later held its hand does not help them enforce the guarantee. So you can't say, well, we didn't say that we would forbear, but we did forbear, and so that's good consideration to bind the guarantee. That is what we call past consideration, amounting to no consideration at all. Okay, and that's in the chapter that you should read, but it's a topic that we don't really address directly. Okay, then after the indented quote from Laskin, the BC Court of Appeal goes on to say, I must say I find Laskin J.A.'s dissent more persuasive than the approach taken by the majority. So we can see how precedent works. Courts can apply the law of BC. A BC court can apply the law of BC. They can apply law from another jurisdiction, and they're doing that. They can consider other cases from other jurisdictions or cases from BC. They can distinguish it if they don't think it applies, and then they can also overrule cases, but they can only do that within BC. So what they're saying here is we would overrule that decision if we had the authority to do so, but we don't. So what we're going to do is we're going to follow the dissent, not follow the decision. Just a couple of comments on the International Convention on the Sale of Goods. This is a law that applies to all three jurisdictions in North America, and it came into effect in 1988. And it has four parts to it. The first part are just general provisions about the setup and how it was passed and everything. Then part two gets into the formation of contracts. And very clearly you can start to see differences between common law and civil law, and the fact that this is a really civil law document. And then part three is the rights and obligations of the party. That's just who gets to sue whom for what, for breach. And then the fourth part is how you ratify it. And as far as the law of the United Nations goes, it can only become the law in Canada and only become the law in the United States and only become the law in Mexico if those jurisdictions pass ratifying legislation. And interestingly enough, I think I mentioned earlier, the international sale of goods had to be ratified by BC, by Alberta, by Ontario, Quebec, everybody, and they've done that. Same thing in the United States, because contractual law falls under the states as well as the federal government, then obviously the states had to have ratifying legislation. There had to be ratifying legislation for the Free Trade Act, for the North American Free Trade Act, and also for now the USMCA. Okay, the slide 89 shows all the countries in the world that are signatories and have ratified the International Convention on the Sale of Goods. And so if you're dealing with any of those countries, the presumption is that the convention applies. Now let's say you're dealing with Brazil, which you can see on that diagram is not a signatory. You can put a clause in that contract whereby Brazil says it will abide by and agree to adopt for the purposes of this contract the Convention on the International Sale of Goods. So if you're not a signatory, you can opt in. If you are signatories, you can opt out. Okay, then there's the tort law video, which I want you to watch, and we will have, once you've done that, a review problem. Hopefully we'll be able to do it online as soon as I figure out how to do an online face thing, because I'm a bit of a dinosaur. And so you'll note that I did it for BADM 107 section 76, and I refer to chapter 4 in the lecture guide, but it relates to the old textbook. Okay, and so ignore that. It's chapter 2, which I will post online, and it applies to our class. Okay, just to finish up, there's 3 short slides I want you to look at. The first one will deal with in a little bit more detail than the other 2. There's a concept that I've dealt with in all my law classes, and the difficulty with law and something like the North American law is that you really do very often require the services of a lawyer. And this screen has 9 bullets on it. It's slide number 92, and it has some hints on how to use your lawyer's time effectively. The first one is find a lawyer you like, and this does not mean find a lawyer that you don't mind, kicking back and having a brewski and watching a football game with. I mean, maybe that's part of it, okay? I had a client who was very upset when I retired because he liked working with me, and he would take me out to a hockey game and we would have a beer. But that was separate. What he liked about me was that he could call me and get through to me when he wanted to. Okay, so that's what. Find a lawyer that you feel comfortable working with. Find a banker you feel comfortable working with. Find an accountant you feel comfortable working with. Find an insurance agent you feel comfortable to work with, because these relationships are important for your business operation. Okay, this is the really important one. Get your lawyer on time. So if you have a 2 o'clock appointment, get to your appointment at 5 to 2. That's not what I mean. Don't send a contract to a lawyer that you've signed and say, what do you think? Okay. And I'm not being facetious. I had a client, my all-time favorite client, Ray, gave me so much legal work. It was unbelievable. Sent me down a lease. He was in lease premises, and he just did a midnight move. He left, and he leases new premises because he was going to pay. The basic rent was way, way less than the rent in the previous premises. And he sent the lease down to me, and it was already signed. And he said, look at what a great deal I did. And I reviewed it, and I called him and I said, Ray, am I supposed to, comment on it? And he said, well, yeah, just let me know. Well, in the first premises that he was renting, he paid rent, one sum, and it was, I don't know, $6,000 a month, okay? And in the other premises, it was $4,000 a month, basic rent. But it was a triple net lease, okay? So he had a basic rent, then he had his proportionate share of the operating costs, his proportionate share of the taxes for the building. So he was paying $6,000 there, and under the new lease, he was paying over $8,000. And I told him that, and he went, oh, because he didn't realize that he signed a triple net lease. because he didn't send it down to me before he signed it. Compare that situation to the fellow that I said would take me out to an occasional hockey game. He had leased premises, and he needed 2 other locations. And so he negotiated with 2 different landlords, and on each occasion he said, the lease will be between between the landlord and my corporation. Okay? And they said, well, we want you to sign a personal guarantee. Funny thing, we're just talking about that, eh? Under a lease, it's called a covenant, okay? Because it relates to land, whereas a guarantee relates to other than land businesses. So they said, we want you to sign a covenant. He said, no. I have a long-standing operating business. It's a franchisee of a huge franchisor. It's solid. I am not signing a personal guarantee. I'll go somewhere else. And the landlord said, yeah, okay, sure, fine. We'll enter into a lease with just your corporation. The reason they did that, of course, was there's lots of space available, so my client could easily go somewhere else. So they thought, well, it's better to have somebody on the lease, particularly a solid corporation like that, okay, than to have nobody. So then they prepare the lease and they send it down to my client. My client sends it down to me with a question. There is a line, the name of my corporation per authorized signatory, where I'm supposed to sign. There's a line right under that with my name below it. I'm supposed to sign there, and it's got a red seal beside my name. What's that about? And I called up my client and I said, that is you personally covenanting that if your corporation cannot pay, you will. And he went, no, that's not part of the deal. I specifically said I would not guarantee the payment. So I called up the landlord, and it happened like in both situations. Okay, different landlords did exactly the same thing, and they both gave the same answer. Why, if the deal clearly was no covenant, why is there a line for my client to sign a covenant? Oh, golly gee, really? Oh, gee, is that in there? Oh, you know what happens? I make the deal, and then I give it to my staff. They prepare the lease, and we usually get covenants, and so they automatically put it in, and we send it out, and gosh golly gee, it's just a mistake. Maybe it was just a mistake, and I certainly hope so, but what would happen if my client signed there? And then 2 years down the road, there's a problem, the corporation goes insolvent. The bank or the landlord would come and say, hey, you signed a personal covenant. And my client would say, but that was not part of the deal. And I'll bet you, and I know, that in both those contracts, there was an entire agreement clause, which said this contract represents the entire agreement between the parties, and all verbal and oral representations are not binding. So it was an oral agreement. Yeah, we will charge you, but the contract says we will. Can't bring that in, you're bound. And the judge would say, if you didn't mean to sign it, why did you? Or why didn't you take it to a lawyer? And if you signed it and didn't take it to a lawyer, the judge goes, like, okay, you're bound by it, all right? So get your lawyer on time. Means go and get assistance before you're in hot water. Take a shopping bag. Shopping bag, Gucci briefcase, big sack, cardboard box, I don't care. What this means is take all the documents that you think your lawyer will want to look at when you meet with him or her, and take a few more, just to be careful. My all-time favorite client, Ray, stiffed numerous other businesses and lawyers, didn't pay his bill. I said, sure, I'll be your lawyer. And I said, but I don't do any work for you that you do not pay me in advance, a retainer, okay? He agreed, and he did. But one day he called me up and he said, I've got this contract and, blah, blah, this and blah, blah, that, and what do you think? Well, if I give it to advice over the phone and then bill him, he'll never pay. So I said, Ray, what I think is you bring $200. That'll cover about 1 hour of my time. Come on down to my office and we'll review the contract. He comes down to my office, walks in, gives me the $200. I count it. And then we sat down and we started talking about the contract. I said, well, let's see it. Oh, I didn't bring it, but let me tell you what's in it. I'm going to give him legal advice on what he tells me is in the contract. So I said, no, Ray, go back to your office, get the contract, bring it back along with another $100. So he does that and he comes back. Comes in the door, gives me $100, and I count it. We sit down and we start going through it. And I said, well, you know, this, that, and the other thing. And he said, yeah. But he emailed me and I emailed him back and then he emailed me. And I said, oh, well, actually it wasn't emails, it was letters. And he, you know, I wrote to him, then he wrote back to me and I wrote to him, blah, blah, blah. And I said, well, okay, let's see the letters. Oh, well, I didn't bring them, but let me tell you what's in them. I got letters affect the draft of the contract. No way I'm going to let him tell me what's in the letters. So I said, Ray, go back to your office, get the letters, get another $100, come back and see me. And by the way, if there are any other documents that might pertain to this, bring them too. Okay? And he did. You know, water off a duck's back with him, but he spent way more money than he had to. Okay? Watch the word we, and do not use legal terms. You can read the article that I got from the newspaper. It's in the lecture guide materials. Read it because it explains these in more detail. It's on page 11. It said, avoid describing your problems in legal terms. You often try to use legal terms, but unless you actually know what those terms mean, you might use them incorrectly and lead your lawyer astray. And then watch the word we. I had a perfect example of that. An elderly couple came into my office and they said, we have been in partnership for 35 years and now we are going to sell our partnership and we want to make sure that we have no subsequent liability. So we discussed it for a long period of time, and then they're leaving the office, and the lady stops and she turns back and she says, okay, just one more question. What do we do with our shares? I said, what shares? And I said, well, our shares in the corporation. And I said, what corporation? And she said, well, we've been in partnership for 35 years in our corporation. And I went, okay, come on back in, sit down, let's go through this, and I'll now tell you how you prevent having any contingent liability if you sell your corporate shares as opposed to selling an interest in a partnership. So again, I think I mentioned it earlier, do not ever call yourself partners if you are in a corporation business, okay? All that does is shoot yourself in the foot, because if you say, oh, we're partners and there's a problem, you will be sued as partners, which means you have joint and several liability. Whereas if you say, I'm the president and this is my business associate, the secretary of the company, we are the officers of a corporation, and then there's a problem and the corporation gets sued, they cannot pierce the corporate veil and make you liable, called agency law. Remember that, okay? So you have to be very careful about using legal terms and and watch the word we, okay? Explain trade jargon, that goes a no-brainer. My two software clients that I talked about that had that agreement with the huge United States company, the no fair negotiation clause, when they were setting up their corporation, they came in and they sat down and they started describing what they were going to do in the way of computer programming. And I was sitting there like, I had no idea what they were talking about. Finally, I said, look, stop. You guys are computer nerds. You're talking to a dinosaur. I have no idea what you're talking about. So you have to explain trade jargon. Okay. And just, another example of what I'm talking about is I'm an amateur astronomer. Okay. I got a big telescope and I go out and look at the stars. When I started out, I began reading one astronomy magazine, and it was for the professionals. And I'm reading this and I'm going, and I had no idea what they're talking about. And I thought, oh, this astronomy stuff is like really, really mind-boggling. And then I found another magazine, I opened up and I went, Oh, that's what they meant. Oh, that's what they meant. Okay, because they took the time to realize that the person reading this particular magazine wasn't a PhD in astronomy, and they explained trade jargon. Do not give instructions by telephone. Okay, that's a bit old. You can give instructions by telephone, but what they mean here is face-to-face communication is really important, okay? And I'm going to try to figure out how we can do our coaching hours or office hours online, because I like to watch my students. And the reason is, if you email me a question and I email you the answer and you go, and you don't understand it, I don't see you go. And I presume that I have communicated correctly. Maybe I'm using too much jargon and you don't understand. So if you're in my office and you go, then obviously I can see you. So what they mean is just be careful with telephone communications or email communications. I had a really sophisticated client come in. He was having a patent dispute inside a corporation, and they were going to have this directors meeting at the 6 o'clock in the, pardon me, oh, sorry about that, 6 o'clock in the evening, and it was going to be very contentious. So we had this meeting, and I said, he was the president of the company, and I said, okay, Jim, here's what I want you to do. I want you to do this and this and this. And he, okay, blah, blah, blah. We talked a bit longer, and as he was leaving, I said, okay, Jim, if you need me there, just call me later in the day and tell me, and I'll go and help you out. And he said, okay. And then I said, Jim, by the way, just stop for a second. He said, what? I said, what was it I told you to do? And he said, well, what do you mean? I said, well, what did I tell you? And he said, well, you just told me. And I said, okay, like, humor me. What did I tell you? And he said, well, you told me to do this and do this. And I think there was a third thing. Well, had he gone off and done the first two and not the third, and there had been a problem, I might get sued for negligence. I told him what to do, but I didn't confirm it, all right? And 2 years down the road, the judge is going to have to decide whether he believes the client or me. And as a professional, I should have done a better job, right? So what I did was I told him the third thing, and then he left. And this was before emails. So I immediately took out a fax sheet and I said, Jim, just confirming I told you to do this and this and this. And if you need me at the meeting, give me a call, Peter. And I faxed it through to him because two reasons. Number one is I will not get sued, okay? Or, well, I might get sued, but I'll be able to defend myself. And more importantly, my client will not forget to do what he was supposed to, and then there will be a better relationship. So you got your, you're on your cell phone, those really important business people you see talking on their cell phone every minute of the day, and you give instructions on your cell phone, and what do? Well, you got that text button. Text. Just confirming my telephone advice. Bingo. Okay, and then you've got a written confirmation to protect you. It's called a CYA, cover your, and it'll make things go smoother. Okay, make referrals. This is just part of good business. As soon as I became a lawyer, I made a relationship with two accountants that I knew. One from when I was working at the Federal Business Development Bank. He was a credit officer too. He became an accountant. I became a lawyer. We stayed in touch. And then the other one was a student of mine who was going through the CA program, and he took my business law course. I had a relationship with him. Whenever I had a client that, I would set up something and I'd say, okay, you should talk to an accountant. Oh, I don't have an accountant? I would say, oh, here's a couple of business cards. Call these people. Find one that you feel comfortable working with, okay? And I would send them clients. They would send me clients. That facilitates a working relationship. I need a quick answer to a question on a file, and it's an accounting question. I call. He's not in. I leave a message. He comes back from lunch. I say he. I'm not being sexist. They were both males. Okay. Anyway, there are 5 telephone messages on his desk. Oh, one from Peter Holden. Okay. He'll probably call me back first. I call him back first. It's just natural. And then the last one is really important too. Be frank about accounts. The first question, or I guess the second question you should ask a lawyer when you sit down is, can you help me on this? Yes. How much is this going to cost me? Okay, it's really important because arguing with your lawyer or with your accountant or whatever about bills is counterproductive. Okay, I don't think Bill Gates ever talked to his lawyer when the first words out of his mouth was or weren't, how much is this going to cost me? Okay, it's not being cheap; it's being thorough. If I had a client, former student, he came in and he wanted me to draft a supplier agreement. So we started talking about it, and I said, "Okay, Vince, what are you supposed to ask me right now?" He said, "I don't know. What do you mean?" I said, "You're supposed to ask me, how much is this going to cost me?" And he said, "Oh, well, yeah, I remember you said that, but..." I said, "But what?" And he said, "But I didn't want to sound cheap." Don't worry about talking about money with a lawyer. We love money. Okay, we'll talk about it all day long. But it prevents problems, okay? I have an anecdote, but it's we don't need to talk about that right now. All right, the last slide, so this is the last portion of the lecture material that I'm doing for the summer term, is an addition to the arbitration slides that I put up at the beginning, because I put something that I found in the lecture materials, okay, which you can buy at the bookstore for about $2. One of the disadvantages of arbitration, well, let's back up. One of the advantages of arbitration is you get one shot at it. And if you win, you win. If you lose, it's over and it's done with, and you get on with business, you get on with life. And that, as well as being an advantage, is also a disadvantage. And that is that sometimes you lose when you should not have. And you do not have an appeal procedure, right? The BC International Commercial Arbitration Center, which is one of two key arbitration centers in Vancouver, recognized this problem. And so what they did was, inside the arbitration process, they have put in an appeal procedure. Okay, so you get into arbitration in 3 to 4 months, and you have your arbitration and you lose, and you think, that is totally wrong. You can have a very quick appeal to another level of arbitration, okay, just to make sure that there wasn't a, somebody dropped the ball. This makes the fact that you cannot appeal to the courts a little less severe, but it also chips away at the speed with which an arbitration can settle everything. So it's sort of a blessing and a curse at the same time. Anyway, I had to add that because it's an important addition, I think. That concludes the lecture component of the course. I am going to work with Ella and Grace to see if I can figure out how to do some face-to-face for the exam reviews and things like that. But thank you very much.